Great. Thanks, Ken.
That's fine.
You ready?
Yeah.
Okay. Welcome back, everyone. Our next panel is Educational Reform Efforts in West Virginia. This panel will examine educational reform issues in West Virginia. Among other things, it will discuss the school consolidation movement in West Virginia in the 1990s and the resistance then and now to that movement. Additionally, it will include a discussion of the Kanawha County school textbook battle in the mid-1970s. I'll go ahead and turn it over to our moderator, Professor Bastress.
Okay. Thank you, Lexi. So we're going to proceed in this fashion. We'll start with Bren Pomponio, who's second to my left here, who is currently an attorney with the Mountain State Justice Organization, which provides legal services to poor and has engaged over the years in a considerable amount of educational reform work, as well as other kinds of reform. And he will discuss the landmark West Virginia case on school finance, Pauley versus Kelly, which has had an enormous impact on education in this state. And he will be followed by Professor Josh Weishart, who I think you all know is on our faculty here. And he will put Pauley in sort of its national perspective, where it fits in the big picture of school finance litigation, which has been going on in this country since 1974, and before that, because that's when the appellate cases started coming in. I think Pauley has a role in that big picture. And then we'll turn to Mr. Trey Kay, who is on my immediate left, who is, how would you describe yourself, an independent?
I'm an independent journalist who has a podcast on West Virginia Public Broadcasting.
Okay. And Trey, I think, currently lives in New York City?
In the Hudson Valley, New York.
Okay.
North.
And he is going to talk about the Kanawha County textbook controversy of the mid-'70s, which has all kinds of layers to it, and is an interesting study in itself. And then, if we have time, I will finish to talk about the consolidation movement in Kentucky, and mostly about the opposition to that movement, which really mostly occurred in the 90s, but is still going on today. So, and it sort of is, it's a controversy which was created, ironically, by Pauley, for reasons I'll talk about later. Not that Pauley had inspired the consolidation movement, but it created the possibility for it, and it also had many of the same social and cultural issues that the textbook crisis had. So with that, I'll let Bren get started.
Well, thank you for having me. I'll just start right off with sort of the history of the Pauley versus Kelly case. 1975, the 5 parents that had school children in Lincoln County, West Virginia, filed a class action in the Circuit Court of Kanawha County, arguing that the West Virginia's school finance system was unconstitutional. I don't really have a lot of information about those beginning days, because I was not living here and was very young. But I work, the executive director of our organization, Dan Hedges, was working at the time for the Appalachian Research and Defense Fund, AppleRed, and he was involved. And when I started working at Mountain State Justice with Dan, the Pauley case was still continuing, and some of my first legal work that I did was traveling around the state and interviewing county superintendents about the educational needs and deficiencies in their counties, and preparing them for testimony in some of the enforcement phase of the Pauley case. So I have some experience with it. I wasn't there at the beginning. So the plaintiffs in 1975 filed this class action and argued that that the school finance system in West Virginia was not constitutional under the state constitution. Our state constitution in Article 12, Section 1, provides that the state shall provide a system of free schools that provide thorough and efficient education. And the plaintiffs argued that because the West Virginia Constitution provided this thorough and efficient education, free schools for all, and also that the state constitution had an equal protection clause in Article 3, Section 10, that the right to the education was a constitutional right, and if not all children in the state were receiving that thorough and efficient education, then there was an equal protection issue, and the state's financing of that would be held to strict scrutiny because it was a constitutional right. They filed their case in the Circuit Court of Kanawha County, and the defendants, the treasurer and the auditor and state superintendent, State Board of Education, they filed a motion to dismiss, and the plaintiffs filed a motion for summary judgment, and the circuit court dismissed the case, and it was kind of a procedural, I don't know what you call it, it was not proper procedurally, because if the the plaintiffs took that up on appeal, and if the defendants had filed for summary judgment, the Supreme Court of Appeals found there would at least be a issue of material fact, and certainly it wasn't proper to dismiss the case on a motion to dismiss. But since they had taken it up and it was a pretty easy procedural question for them, they could have just disposed of it, but Justice Harshberger wrote a very long opinion setting forth the constitutional basis for the plaintiff's claims, and the court concluded that there was a constitutional right under the West Virginia Constitution, and surveyed the other states in the country that had educational clauses in their constitutions, and some had that the state was required to provide a thorough education, others provided that there had to be an efficient education, but that West Virginia provided both, and basically adopted the plaintiff's theory that if the state wasn't providing that thorough and efficient education, which the court defined as requiring a high quality education, that they would be subject to strict scrutiny and establishing why they had not provided that to all the students of the state. So that opinion, the initial Pauley versus Kelly opinion, was in 1979, excuse me. And so the Supreme Court of Appeals reversed the dismissal and remanded it to the circuit court for proceedings consistent with that. the circuit judge who had dismissed the case, I think his name was Robert Smith, when the Supreme Court remanded it to the circuit court, they also appointed as a special judge to hear the further proceedings, circuit judge from Ohio County, Arthur Recht. And Recht became very famous for his marshaling of that case and his subsequent memorandum, opinion, and order that's often referred to as the RET Decision. Recht took the remand decision from the Supreme Court of Appeals and proceeded to hold months of evidentiary hearings regarding the method of financing of the schools, public schools in West Virginia, and the shortfalls, the deficiencies in the schools. There was a lot of evidence put on about not adequate access for the students to curriculum, failing facilities, not adequate access to musical instruments, access to the arts, and even more fundamental curriculums like math and science. There was also a lot of evidence about the financing of the schools, and at the time, my understanding was that there was a heavy emphasis on school excess levies that were passed, and in sparsely populated counties like Pocahontas County, Calhoun County, Lincoln County, they just weren't able to raise that type of money sufficient to have the teachers that gave the students access to the minimum standards for high quality education, and to maintain facilities that would be considered consistent with the high quality education. I think it was around 40 days of full days of evidentiary hearings were conducted, and they were conducted primarily in Charleston, I believe. And so Judge Recht would come down for those, and the Supreme Court had said that expert testimony was necessary for establishing these constitutional inadequacies in the schools. And in May of 1982, Judge Recht issued his decision finding that indeed the state was failing its constitutional duty to provide high-quality education. And the order was 232 pages or something like that, and very comprehensive. He concluded that the plaintiffs had made out this constitutional violation, and he ordered that a special commissioner be appointed and a master plan be developed to address the financing problems and the facilities, curriculum, all the inadequacies in the school finance program. When Recht issued his opinion, there was widespread panic with the elected officials. And when I was preparing for this, I found a May 14th, 1982 Charleston Daily Mail story about the RET decision. And it's funny because I'll read you some of the quotes from some of the elected officials, and they're you know, Chicken Little type of responses and statements, and but then they conclude with saying that they hadn't read the opinion and they'd have to reserve judgment on it. The Speaker of the House of Delegates at the time was a man named Clyde C. And he predicted that the legislature would that the legislature would ask the voters to pass a constitutional amendment to undo the decision. The finance chair for the House was a man named Charles Poland from Cabell County, and he warned that this was going to be akin to Proposition 13, the California proposition in the late 70s that caused a big uproar out there. Governor Rockefeller at the time said, quote, the decision will, quote, mean enormous increase in taxes for all West Virginians. And the governor said he needs to study the opinion before making recommendations. Speaker C said that there are 70,000 people out of work in this state and we're going to raise their taxes. No way. We're having a heck of a time keeping business in the state, and this just drives another nail into the coffin. The Attorney General then was Chauncey Browning. He said he was distressed that the court was deciding how much money our citizens should spend on their school system, and that educational expenditures already totaled nearly 50% of the state budget. He estimated the cost for implementing these changes that Judge Recht proposed would be in the hundreds of millions of dollars annually, and that although we want to see a good school system, that because the citizens have turned down these excess school levies, that he thought that the taxpayers were satisfied with the present system. I guess it was a 244-page order. And Browning said he'd have to study that before he decided whether or not they would appeal. Ironically, Judge Recht was appointed to the Ohio Circuit Court of Ohio County by Governor Rockefeller. The speaker also said that he thought that it was a violation of the separation of powers, and Judge Recht's decision was unconstitutional, and they go on and on. So that was the days after Judge Recht's decision. But 5 months later, by September of 1982, nobody had appealed the decision. And so Judge Recht went and permitted the superintendent and the Board of Education to fashion a committee to come up with this master plan that he had ordered. So the state superintendent and the Board of Education assembled a 99-member committee to come up with this master plan, and they were able to come up with something to give to Judge Recht within it was less than a year, I believe, and it was 356 pages, and it was considered by Judge Recht when he approved it to be a very comprehensive plan, and he stated that it appeared to have met the mandate that the Supreme Court of Appeals had provided in the original Pauley versus Kelly opinion with, quote, fidelity. The legislature enact some legislative measures to change the financing of the schools, and I think that the change in focus of the school financing program went to what's considered a performance-based accountability type method, where the concept is to invest on the front end so that what flows from the system would be a high-quality education, rather than assess the deficiencies on the back end and throw the money at it that way. That was the theory. One of the most significant results of that master plan was the establishment of the school building authority, and Professor Bastress mentioned that, but it was responsible for providing millions and millions of dollars to improve school facilities, and to the extent that the school system in Lincoln County and many of these other rural, sparsely populated counties were so dilapidated, and to this day, Fayette County has been in the news recently because their facilities are so poor. I mean, the horror stories are really atrocious. My sister graduated from Meadowbridge, which is in, I think Meadowbridge is actually in Fayette County, but serves Summers too, or it might be the other way around. And you had literally windows falling in on students and the roof falling in on students and that kind of stuff. But the SBA went a long way to addressing a lot of or addressing it, maybe not fixing it. And I'll let Professor Bastress talk about how the consolidation debate fits in with the SBA's mission. But I have to say that just is responsible for putting a lot of resources into facilities in West Virginia, which was obviously a very big problem. After Judge Recht confirmed the master plan, the plaintiffs took the case up to the Supreme Court of Appeals again, arguing that Judge Recht had his order confirming the master plan was deficient in two ways. One, that Judge Recht had not provided a timetable for the implementation of the master plan, and Justice McHugh, authoring the opinion of the court in 1984, basically found that there was no evidence that the plaintiffs presented that the failure to include a timeline, specific timeline for that implementation was going to result in a constitutional violation. And I think basically Judge Recht and the Supreme Court decided that they had pointed the state in the right direction. Judge Recht had always been very mindful of the fact that he could not, consistent with separation of powers, order the legislature to fund schools. And so I think that they felt like a lot had been done to come up with the master plan, and that the state ought to be given the opportunity to meet the goals of that plan. But the plaintiffs had argued the Board of Education hasn't done anything consistent with implementation of the plan to the date by which the plaintiffs had appealed. And their evidence were the regulations that the board had passed after the adoption of the master plan, and they were strikingly similar to the inadequate policies that Judge Recht had found were constitutionally deficient. And the Supreme Court acknowledged that, and they said, this is not going to cut it, but we're going to give you the opportunity to get this done. But they declined to issue a specific timeline. During there was three major Supreme Court of Appeals opinions in this school finance case, and Justice Neely was on the court at the time, and he dissented to all of them. And in the very first Pauley versus Kelly case, Neely dissented and concluded that he didn't think that, he thought the court was overstepping their bounds, and that the financing of schools was a legislative prerogative, and so he dissented to all the opinions on the same ground, citing back to his original dissent. So the Justice McHugh's opinion and was in 1984 upholding the the master plan had not been appealed itself, and so the Supreme Court didn't have to issue any decision regarding that, but that appeal was in 1984, and the state went about the process then of trying to implement or stating that they were going to implement this master plan, and nothing happened in the case for 11 years until January of '95, when the plaintiffs filed a motion to enforce. When they filed that, Judge Recht had been appointed to the Supreme Court of Appeals and could no longer serve as the special judge on the case. And so Judge Robinson, Dan Robinson, held hearings, and he concluded that the state school aid formula, which sets out the financing on the state level of county schools based on a ratio of students per county, and it's more complicated than that, but generally speaking, he found that to be unconstitutional. And but the case, the motion to enforce continued for several years, and Judge Recht decided not to run for re-election, ran for re-election, I believe, to the Circuit Court of Ohio County, and got back on the Pauley case. And he conducted a lot more hearings, and that's when I got involved in the case in 2000. and he heard more about the financing adequacies, the lack of access to curriculum for students, and he heard from county superintendents and experts in school finance. And the parties entered into an agreed order in 2000 that set up the Office of Education Performance Audits, which was intended to be a accountability mechanism to assess the curriculum and facility needs in all the schools so that they could be addressed from a financial standpoint. And my understanding is that that audit committee has been disbanded and is no longer. Sam Petzoff let me know about that. I hadn't heard, but that was a significant development from the case as well. And then in January of 2003, Judge Recht issued a final decision in the Pauley case, and a big aspect of his original decision was that he was going to retain continuing jurisdiction over the implementation of the master plan, and it drove the executive agencies and the legislature crazy that Judge Recht was continuing jurisdiction over this. But he ended that in January of 2003 with a hopeful missive that the state is on the right track with this performance-based model, and he felt like he couldn't tell the legislature how to fund it, and so he needed to let it go at that point, and that was the last of the Pauley decision.
Okay, Josh.
Well, since we occupy the envious position, after lunch position on the schedule today, I thought I'd put together a PowerPoint slide so we can have something to look at. So I'm going to cover the legacy of Pauley. And I appreciate the opportunity to be on this panel on a subject I think is most essential to Appalachian justice. And education reform in West Virginia really did begin with Pauley. Now, this was the sentiment of the author of Pauley just 6 years after the decision. I don't share that sentiment, but I have the benefit of 40 years of hindsight. Justice Harshberger was reacting at that point to the RET decision and the response to the RET decision, which we'll cover again real quickly. But I think to really appreciate the significance of Pauley, we need to situate it within the broader national school finance reform movement that began in the late 1960s. In that first wave of litigation, plaintiffs asserted that school funding disparities were a form of wealth discrimination that violated the Equal Protection Clause. These first legal challenges were brought in federal court, seeking recognition of a right to education under the U.S. Constitution. The plaintiffs hoped it would necessitate more equal funding of schools. That first wave crashed suddenly and hard when the Supreme Court in San Antonio versus Rodriguez held that education was not a fundamental right under the Equal Protection Clause, and that poor people and families that were concentrated in high poverty districts were not a suspect class worthy of heightened judicial scrutiny. So that meant that funding disparities need only be rationally related to a legitimate state interest. And the 5-4 majority deemed local control over school districts to be a vital state interest, quote, worth some inequality. In a footnote in his dissent, Justice Thurgood Marshall suggested that advocates take their cases to the state courts and pursue their claims in state court. His co-dissenter, Justice Brennan, a few years later would author a seminal law review article imploring state courts to construe and give effect to the individual rights provisions of their state constitutions. Well, the advocates heeded Justice Marshall's advice and rode a second wave into state court, and state court judges, many of them, heeded Justice Brennan's advice and started to independently construe state constitutional provisions. Pauley was among the first of this second wave of reform. And as you heard, now every state constitution has an education clause. The language varies quite a bit. Maryland, New Jersey, Ohio, Pennsylvania, and Wyoming all have the thorough and efficient language that is found in the West Virginia Constitution. As you heard, Pauley interpreted that thorough and efficient language to be coextensive with the equal protection guarantees in the Constitution. It held that the right to education was a fundamental right that would be subject to heightened judicial scrutiny. Now, if that was all that Pauley did, I don't think we would have much to talk about today, because Pauley wasn't the first court to hold that the right to education is fundamental, nor would it be the last. What makes Pauley unique is that it was the first decision in the country to actually define in substantive terms what the education clause meant. It said that a thorough and efficient education develops the minds, bodies, and social morality of children to prepare them for occupation, recreation, and citizenship. But it didn't stop there. It went further to articulate 8 capacities that a thorough and efficient education would cultivate in children, from basics like literacy and math, to knowledge necessary to meet the demands of citizenship, even competency in the arts and social ethics. This is what's constitutionally required under the West Virginia Constitution. And there was more. The right to education necessitated good facilities, good curriculum, good teachers, and accountability mechanisms, and high quality standards. Let me emphasize again that Pauley was the first decision in the entire nation to define these substantive standards of the right to education. But Pauley was also cutting edge in another way, in how it articulated educational equality. This is a chart in the decision's appendix that shows funding disparities caused in large part by differences in the yield of county taxes through levies and special levies. And I know it's difficult to see, but you can see the imbalance enough that you can see that there's an imbalance by the failure of the state to compensate for differences. Well, Pauley said that the goal was not to achieve fiscal equalization among the counties, or if you will, horizontal equity. Rather, it was to ensure equality in substantive educational opportunity, a type of vertical equity, where differently situated students would have what they need to succeed, no matter what the expenditure would be. That was really pushing the envelope, far ahead of what most state courts were thinking at the time. So why was Pauley not a source of great pride for Justice Harshberger? Why was he so disappointed just 6 years later? Well, as you heard, that was because of the RET decision and the response to it. That decision, in which Judge Rett concluded that the conditions of the schools were, quote, outrageous, and that some were actually a serious health hazard to the students. And not a single school in the entire state met the constitutional standard. There were a few in West Virginia that would have disagreed with that conclusion, actually, at the time. But yet, this decision was met with stiff resistance because I think it demanded too much too quick. It exhaustively detailed what a thorough and efficient education would be, right down to the appropriate square feet for classrooms and the appropriate acreage for facilities. So, for example, it said every elementary student should receive 100 minutes of art education per week. And it said that art education had to be in an art room of at least 65 square feet, with 1/4 of the area reserved for storage. Got down to that minutia. And one estimate of the total cost of the RET decision was $1.2 billion, which was nearly as much as the entire state budget. This at a time when the state was in yet another recession and employment was high. Lawmakers, as you heard, including then Governor Rockefeller, were caught off guard, I think, by the magnitude of the decision. Rockefeller really set the tone. He went on TV and ridiculed the excesses of the decision. Said, basically, look, this decision's calling for heated shower floors and kayaking classes, and that's just really beyond the pale. Now, Rockefeller would later come to regret those comments that he made on the TV, and he in fact actually later supported the decision. But the die had been cast by then. Just 10 days after the RET decision, Judge RET entered a supplemental order saying, wait a minute, I wasn't mandating anything. I'm not usurping the legislature, and none of this is going to require massive property tax increases. And he thereafter, as you heard, appointed the Department of Education to be the special master. Kind of unusual to have the defendant in the case to be the court's special master. But I think Judge RET probably thought he had to do that at that point. In any event, you heard that there was a master plan that was pretty extensive, and the court eventually approves, Supreme Court eventually approves in Pauley 2 that master plan as Judge RET had approved it. Meanwhile, on the national stage, what you had was a third wave of litigation surging towards educational adequacy, with a focus not on whether students have the same access to educational resources, but whether they had enough to meet certain quality educational standards. If that sounds familiar, that's because that's precisely what Pauley had decided 10 years earlier. Yet it is the Kentucky Supreme Court's decision in Rose versus Council for Better Education that is credited with ushering in this third wave of litigation. And most likely that's because the Kentucky decision invalidated the entire Kentucky public education system. Not just the school financing, the entire public education system. All the statutes, all the regulations were invalid. Now Rose has since been adopted and relied on by nearly every successful school finance case for two decades nationwide. It's frequently cited for the definition of adequacy and specifically for its 7 capacities that are articulated for all students. Notice in bold the overlap with the Pauley's 8 capacities. So essentially, Pauley laid all the groundwork, Rose took all the credit. I'm not bitter. The third wave has enjoyed far greater success than the first and second waves. Plaintiffs prevailed in approximately 75% of all adequacy cases from 1989 to 2006. Then, of course, we had the Great Recession, and states started to drastically cut their education budgets, some by as much as 20%. That's when courts started to basically reject adequacy cases. And now some of that could be attributed to economic and political realities, but I think that the predominant reason was that courts started to retreat because they started encountering resistance from the legislatures. In some instances, the legislature just refused to comply with the court order. In one case, we have the Washington Supreme Court taking the dramatic step of holding the legislature in contempt for failing to comply with its order. Now, the problem with adequacy in particular is that it requires state action. It requires the state to develop curriculum, to set high standards, to make sure that the funding is adequate, to have accountability mechanisms to meet those qualitative thresholds. And some courts still harbor reservations that by doing so, they are intruding on separation of powers, right? By even suggesting how you might go about remedying the situation. All of that, the tension, as you heard, was evident in West Virginia. Governor Arch Moore was adamant that he would decide what was best for the education in West Virginia and not, quote, some circuit court judge. And the legislature basically took the same attitude, and that's why you had virtually nothing happen in the 80s. Again, by the 1990s, 1995, we had the plaintiffs intervening and trying to push forward that master plan. That does get some traction, though Judge RET basically says it's not adequate, but I'm going to let it proceed. And I'm going to terminate the court's jurisdiction because I think any progress now has to be made in the legislature and executive branches. Basically, the judge was sounding the retreat. Now, because he wrote the book on West Virginia Constitution, is moderating this panel, I would be remiss if I did not share Professor Bastress' thoughts on Pauly's impact. So Professor Bastress points out there's been greater investment in education as a result of Pauly, that the state has assumed a much greater responsibility for the funding of public education, that there is now a meaningful schools facilities system and investment in construction and renovation, and a very high degree of inter-district equity as measured by per pupil spending. Now, I think that there's evidence to support all those assertions. I think they're absolutely correct. And yet, I'm not sure that that means that the public education system meets the constitutional standards that were interpreted in Pauly. There's certainly greater investment in education. In fact, in comparing state education relative to the state's fiscal capacity, in other words, state fiscal effort, West Virginia ranks consistently high in that measure. We fall sort of in the middle of the pack when it comes to per pupil spending. But we're spending about 12% less on education than we did before 2008, adjusted for inflation. That doesn't reflect what Pauly declared, which is that the financing of education is the first constitutional priority for the state. That's what Pauly said. Our funding formula is resource-based, meaning it determines the cost of delivering education based on district costs, resources, primarily personnel, and as a function of student enrollment. That's in contrast with student-based formulas that assign costs to education, a base amount, and then adjust to add additional costs for educating certain student categories that might need some remedial compensatory services. They are more expensive to educate. We don't do it that way. While we're on the subject of personnel costs, I couldn't help but point out that West Virginia has consistently ranked near the bottom in terms of teacher salary and wage competitiveness. Now, a resource-based model, a formula, may be fine if the goal is horizontal equity, right? But again, Professor Bastress is correct that per pupil spending across districts is more equal now, as you can see from this chart. But remember that Pauly insists on that this is not the ultimate goal. This is not educational equality. Instead, vertical equity, or spending adjusted to the needs of students, is what Pauly prescribes. And on that score, the state's funding distribution is regressive. In 2014, our fairness measure was ranked at a D, and we've leveled out to a C now, so we're flat. But the trouble is, we just don't direct enough additional funding to students from low-income households, even though there is this state program-based allocation for high-poverty districts. As for adequacy, the educational outcomes are not favorable, at least not by those measured by test scores in reading and math. Remember the first two capacities that Pauly articulated. By other metrics, the quality of West Virginia education ranks low. By this particular measure, we rank 48th in K through 12 achievement and 48th in chances for success. And we rank dead last as one of the least educated states in terms of the percentage of our population with post-secondary degrees. Of course, there's some other favorable data points that I could have pointed out to you, but I think the preponderance of the evidence is to suggest that our schools are not adequate. Now, unlike Justice Harshberger, I haven't lost hope in our schools. Indeed, I think there is hope only because we have the Pauly decision. But it's going to take more than lawsuits and judicial action for real change to occur. And I think that might be the lasting lesson and legacy of Pauly.
Trey.
Okay.
You want me to help?
Could you please?
I'd be happy to.
Hi. So I'm, as he said, as Professor said before, I'm Trey K, and I am a radio journalist, and I do a podcast for West Virginia Public Broadcasting. I think Hal, do you have the clicker?
Yeah.
That's my podcast, the logo, the us and them. How Professor got to know me is back in 2009. I made a radio documentary called The Great Textbook War, and I'm going to tell you a little bit about the story of the Kanawha County textbook controversy in 1974. If you go to usandthempodcast.com or West Virginia Public Broadcasting, the documentary's there if you'd like to hear it, if this story fascinates you at all. The way I like to tell the story and the way I started on the documentary is, it's 1974, I'm a 7th grader. I grew up in the South Hills part of Charleston, and I'm riding a school bus to John Adams Junior High School. And the bus is going by the gates, and all the kids are looking off to the left-hand side of the bus, and we see a bunch of women with protest signs saying things like, "Get the devil books out of the schools," and stuff like that. And I remember there was some sign that said something like, "I have a Bible, I don't need those dirty textbooks." And I remember thinking, dirty textbooks? Are we going to be reading Playboy? So at that time I had no real idea as to what was going on. But I see a lot of people who are a lot younger than me, maybe some people are not, but this was 1974. Right at this time, President Nixon has just resigned. The Watergate scandal, the Vietnam War is grinding to a kind of an inconclusive halt. We're still engaged in the civil rights movement. We've had, Kent State was, I think, 3 years before this.
1970.
Okay, 4 years, right. I thought 71, but okay, yeah, right, you're right. So we have probably gone through a period of time where I would think we were probably at the apogee of maybe liberal counterculture revolution, that type of thing. We are about 9 years after the Elementary and Secondary Education Act of 1965, where there had been a huge infusion of cash from the federal government to really try to address this thing called the achievement gap, and where we were trying to invest money that was looking at really with a focus on Black and Latino urban culture schools and their achievement gap in the test scores, and how was it that we were going to produce textbook material that was going to relate to a group of people in America who did not seem to be included in education materials that were mostly geared to white people. And so right around in the early 1970s, the West Virginia State Legislature adopts a mandate that that all of the textbooks, the curricular materials, text materials that were adopted by I guess the state of West Virginia had to be multicultural in nature. And so this is right around the time of 1974. In April of 1974 is when the Kanawha County Board of Education is up to adopt language arts textbooks. And these are, just to make sure we're clear what we're talking about, these are reading textbooks, learning to read books, and then the books of the books that we read after we learn to read. There was a great deal of effort to have African American and Latino faces in the books. This is the first time that you would have seen stories by Gwendolyn Brooks, Langston Hughes, those types of authors. Langston Hughes, James Baldwin, those types of authors appeared in the books. There was also an effort and this kind of came up in one of the first meetings of the adoption, where there was something that oh God, now I'm blanking on the term, but what we know about now, and what we've probably heard about late in more recent years, is ebonics, where there was oh God, I can't believe I just forgot the term that they were using at the time, but this was one of the things that a conservative member of the school board, who was her name was Alice Moore, and she was a preacher's wife, and she was not from West Virginia. She was from Tennessee, very conservative, religious woman, and she had gotten animated with regard to engaging in the school system because she had heard that they were going to be teaching sex education in the schools, and that motivated her to run for the school board. She really appealed to the more fundamentalist constituents of Kanawha County in West Virginia, and she made it on the board. And she was seated on the board when they were adopting this series of language arts textbooks. The first thing that bothered her was this, and gosh, I'm still bumming that I cannot remember the name, but this ebonics thing. That I'll call it ebonics for right now. That was something that really bothered her. On a provisional vote, to just kind of on a provisional basis to adopt these textbooks, they adopted them. They're going to do like a little more review, and at the end of the meeting had gavelled closed, and her husband, the preacher from St. Albans, West Virginia, had been sitting in the back of the room, and he had been kind of flipping through the textbooks that were up for adoption. And after the meeting, he walked up to her and he showed her a passage, and he says, "Look what you've just adopted." And read a passage from the autobiography of Malcolm X, and I'm paraphrasing what it said, but it said, "All praises are due to Allah that I had this change, and that I'm not a brain dead Christian," or something like that. Well, you can imagine what a fundamentalist minister would have thought of that. And so this Alice Moore wrote to the superintendent of the schools, and she said she wanted all of these books delivered to her house, and she went through and she, with a fine-tooth comb, read as many of them as she could. And as she did that, after she did that, she went on a kind of a crusade, or if that's what you'd like to call it, but through the county, each church and community group brought them together, and she had, her noted books and showed everybody and read passages. I actually have some audio of just one of those meetings that didn't make it in my documentary. I got it afterwards. What ended up happening was that there was a great deal of alarm from people in the county, and parents started protesting. The things that they were most concerned about were that they felt that the books were unpatriotic. This, as I said before, this was the time of the Vietnam War, so and there were a lot of books that would have encouraged students to kind of get in and think about the issues of the Vietnam War, and I remember one particular story that had to do with a father and a son just kind of having a debate about the issues of the Vietnam War. A lot of the stories were considered to be anti-Christian. One of the more famous anecdotes was that in one of the, I forget what grade level, but they were reading Androcles and the Lion. And you read the story, and there wasn't really much about Androcles and the Lion that you could think of that was really controversial at all, except if you happen to be looking at the teacher's edition of the book, and they were looking at the discussion section of what it was that you were to discuss with the students. And it would say something like, well, we can tell that Androcles, or that the lion it speaks, and so therefore he's anthropomorphized. I mean, we don't really know of lions speaking, so therefore this is an indication that this story is a myth. And then a couple other discussion points, and then later on says, maybe you should suggest a discussion of comparing this story with, say, Daniel and the Lion's Den. that didn't go over very well, and it was it didn't go well. So and I don't know how many people here know Kanawha County. Obviously, the state capital, the county seat, at that time was a big education but industry hub of the state. A lot of educated people lived in kind of in some of the more urban pockets. A lot of PhDs who probably would have come into work like at Union Carbide and those areas. And then in the outlying areas, I don't know if anybody knows my podcast. I did a piece that has gotten a lot of national attention called Hillers and Creekers. And the Hillers were usually people who lived in the South Hills area, the Edgewood area. They were more educated kids who probably were going to be college bound. And the Creekers were in the low-lying areas, working class people. Probably many of them still that I know today didn't have college in their future, and their children haven't either. That really, it was kind of a battle, these textbooks in many ways, and I'm just speaking in general terms because there was all kinds of exceptions to the rule when I did the reporting for this, but it really did kind of seem like a battle between the Hillers versus the Creekers. So a lot of the local fundamentalist preachers got involved. There was a whole host of them really leading protests. There were parents. This is up in Campbell's Creek, West Virginia, and I don't know if you can see that, but even hillbillies have constitutional rights. We know the difference between communism and freedom. The protest got very animated in that same area, Campbell's Creek. I remember this made the national news. This was on all the major NBC, ABC. Jed Duvall, I don't know if anybody remembers that, he was a reporter for CBS, and he went to a rally up in Campbell's Creek, and he had the piss beat out of him, and they stole his camera. And this really became a really animated, violent protest. There were, I should throw this in, there were a lot of the areas, they had a lot of these protesting mothers, as I described before. Well, who was the husband in that family? He was probably a coal miner. The local unions had a shutdown of the coal mines, so there had a big economic impact on the area. And then other unions, the bus line union, the unions that would transport food to the local grocery store. So the economic impact of this was really significant. And just if you think about these times where we've had the Vietnam War protests and the civil rights protests, this is, I think, significant because you have people, the people who Richard Nixon would have appealed to, who would have said, you are the great silent majority. You are the Americans who are not protesting on college campuses and stuff like that. You want law and order. Well, this is a significant situation where people who you are the last people you would expect to kind of get up and do this type of protesting. They're doing things that you just wouldn't expect them to do. There was a school-wide boycott there's a county-wide boycott. So most of the schools that were in these areas that were the more rural areas, parents kept their kids from going to school. They had protest, what do we call the things, where picket lines, where you have the picket lines in front of the schools, and made it very unappealing for parents who did want their kids to go to school to cross the picket line. I mean, this is Union country at that time, and particularly at that time. I mentioned the violence. There were snipers shooting at school buses, not with kids in them, thank goodness. What? I think I have a picture. There's the coal miners here. I love that picture. Clean books in, dirty books out. Here, let me fast forward just one second. This is a state policeman, and he's showing some of the snipe bullets. I didn't have a picture of one of the school bus, but this is from the textbook controversy. And then probably the thing that I think most people know about from this was that there was a whole series of school bombings. And this is, again, in Campbell's Creek, West Virginia. This is from the Charleston Gazette. I think this one actually is from the school board office in Charleston, the one here on your right. Dynamite, Molotov cocktails. That was probably the lowest point. There was actually, I read the newspaper articles. This is like one of the weirdest things. There was a book protester who was shot, it says in the newspaper articles, through the heart, and he survived. That one I don't get, but anyway, yeah. Eventually they took the textbooks out of the schools for a cool down period. Then eventually, after a while, they brought the books back, and they had a compromise where parents could opt out of their children reading the books. So if it was a certain time of day where they were going to read from a certain passage, little Johnny or little Lexi could go to the library and read or something like that. And that was kind of how the solution worked out. How it worked out in practice, there was some of that example, but in the areas, in the more rural areas, some of these books just never ever came off the shelves. The teachers were just like, this is too much, we'll use the old books. That basically, the way the textbook controversy for the most part ended, that compromise, and then one of the preachers that I had shown you before, I'm not a real good, this guy, Marvin Horan, who was a preacher from Campbell's Creek, he was convicted and did time in a federal prison for conspiracy for bombing the schools. So basically this thing, it started in April of 1974. The compromise happened, I think it was in right before November, right before Thanksgiving, or no, it was in December of 74, and that's when it kind of grinds to a halt. And then it really, the protesters still kind of kept fighting on for other issues and stuff like that. But for the most part, this thing kind of lasted for maybe 6 or 7 months in Kanawha. And it really kind of came to a close after Marvin Horan was convicted. So the professor asked me to talk about the legacy of this. Just several points. The legacy of the textbook, the Kanawha County textbook war. This was a big deal at the time. It was all over the national news. For a lot of the protests, the protesters who had legal problems, there was this tiny little organization out of Washington, D.C., and they were run out of a kind of like a garage, and they called themselves the Heritage Foundation. And they sent lawyers and experts to help the protesters at the time. So this textbook controversy was one of the first kind of legal things legal actions that they got behind. I spoke a lot in some subsequent reporting that I did for some other pieces that I followed up, and I went to New York, or went to meet some of the publishers in New York who were executives at the time, and they basically said that this controversy was something that basically made them quake in their boots, and that the model was you went to Columbia Teachers College and you said, you know what, we want to get kids reading. we want to think of like some type of, you know, real kind of cool way that we could just kind of appeal to kids in a different way right now. You're like one of the best experts who's doing cutting edge things like that. Write a textbook and we'll publish it. That model ended after this. After that, it was getting together, focus committees, you know, making sure that the parents were involved in approving the content that went into textbooks. And I'm going to talk about this just a little bit in closing, but well, I'll mention it now. Subsequent to making this documentary, I went to Texas, which has been having battles over curriculum and textbooks going at least back to the early 1960s. And I did a pretty extensive look at the curriculum battles that happened in that state board of education back since the 1960s. There's a couple that I know some people who are older here in the room might ever know Mel and Norma Gabler. Mel and Norma Gabler were this couple that was from East Texas, and they were just a mom and pop group, and they mom and pop, and they were reading their kids' textbook, and they saw some things that bothered them, and they started this operation on their kitchen table where they just would do a thorough review of textbooks from a conservative Christian perspective. And Mel and Norma are gone, but their operation is still it's just really almost one man who's doing it, but he, you know, assiduously is there reading every textbook that's up for an adoption in the Texas State Board of Education, and the conservative board members really rely on the Gablers organization. After the Kanawha County textbook controversy, pretty much the attitude of textbook publishers was, we're going back to basics. And the Gablers had really started their protests in Texas back in the 1960s. They really picked up steam in the 70s and in the 80s. And so the Gablers actually came to West Virginia to kind of lend support to the protest. The impact of the Kanawha County was just like kind of like a flashpoint that publishers knew about, who really kind of sustained the challenge of really challenging curriculum and textbooks were the Gablers, and they had a significant impact going into the future. For example, and I don't know if you know this, it's not the model now, but it used to be that Texas had the largest purchasing power of textbooks. And so that if a textbook publisher were able to sell a contract to Texas, basically they're in the black. And now everything they sell to the rest of the country is gravy. And that was the model for a long time. And so basically what Texas wanted in their textbooks was something that could arrive to a classroom in Ohio or any other place in the country. I know in my documentary that I did about Texas, I had some archival news footage of a mother in Ohio reading her science book that basically says, you know, anything in here that's about evolution and stuff like that, it's stamped in the front. There's a stamp in the front of the book that says anything in this science textbook that has to do with evolution is all theory, it's not fact, or something like that. So this type of culture war element coming to the discussion of adoption of curriculum and textbook material is something that still goes on today. We see it in the fights over Common Core, and I even think similarly back to the 1970s when we had new math, that quite often there's this disconnect between the educators and people who you think are the most knowledgeable people in the field of education, who are being challenged by parents who in many cases might have been failed by the education system and who really don't kind of have a great understanding of what it is that is being taught to their kids. But as I found when I was researching this documentary, you do want to have these parents engaged. You want to have these parents engaged. You don't want to just all of a sudden say, okay, yes, here we are the experts, and you just go away and let us educate your kids. So it's an interesting phenomenon. I think that's about all I have. But thank you.
Okay.
Yeah.
Do we go to 420?
Yes.
Okay. Well, what I'm going to do is tell you what the consolidation issue was about, and how it developed. It really did, as Bren mentioned, one of the outcomes of Pauley versus Kelly was the creation of the School Building Authority, which was created in 1988. And at that time, West Virginia schools were, their school facilities were abysmal. Most of the majority of them were more than 60 years old, and they had not been maintained well. And the need for building new schools and refurbishing some of them was at a crisis stage. The counties, particularly the rural counties, had not been able to pass bonds to finance school construction. There had literally been a period of 60 years where there had hardly been any school construction in the state. So the creation of the SBA, which the legislature did in '88, and authorized the SBA to sell bonds to pay for new school construction, was a huge step forward. And it coincided with the election of Gaston Caperton, who then took over in 1989 with a pledge to make himself the education governor. And he made sure that the SBA was issuing bonds. We spent hundreds of millions of dollars in the next 10 years building new schools. A little, I mean, it could have been a billion, I'm not sure exactly. And Caperton taking over also coincided with the appointment of Hank Meraki as school superintendent and of Clacy Williams as the director of the SBA. And both were highly committed to consolidating schools. Both felt that this state could not afford small schools. I mentioned that they were in bad shape, but there were also a lot of small schools in small communities in the rural areas around the state. And it was Clacy Williams' view that we couldn't afford them. We had to consolidate schools in order to save money and to expand curriculum and educational opportunities. And he was rigid in his contention about that, even though there was absolutely no evidence to support any of that. And in fact, it's curious that we start this consolidation movement, which, by the way, I should mention at the outset, the beginning in 1989 and running through the 2002, we closed over 300 schools in this state. Most all of the schools that were closed were these community schools serving small rural communities. And Clacy set up a system of priorities which were heavily weighted towards consolidation. Basically, the system was rigged. That if you wanted money from the SBA, it was a competitive process. You had to apply to the SBA based on need and what you were going to do and how you were going to accomplish your goals. And if you weren't consolidating, you weren't getting money. Or at least if you were trying to preserve small community schools, you were not getting money. So the counties were in a hard spot. They were also pressured by the school formula, which made it difficult to operate small schools because the legislature had capped what they would spend on teachers, and so you were limited in your teacher-student ratio. And of course, small schools have lower teacher-student ratios. So this movement begins to close these 300 schools, and it's ironic because at the time this movement occurred, I call it movement. I don't mean it's a popular movement. It's a toply imposed movement, and of course it was imposed in all of these small communities. There were just these battles royale, one after another, in county after county, with the communities resisting consolidation, and it had some of the cultural tones of the Kanawha textbook wars as well, because in most counties, you have a county seat and a town, which is the dominant cultural and if there is wealth in the county, it's concentrated in the town, and all these community schools are in the surrounding areas, in the more rural areas, and of course the townspeople were better educated, had more money, and so forth. So you created this cultural conflict as well. And we were consolidating schools when the rest of the country, which had been on a 40-year consolidation binge, was deciding, oh, maybe community schools are better, and they were going smaller rather than bigger. And it also coincided with a mass of research showing the advantages of small community schools. And you could, I think, by common sense, you could see the advantages that would inhere in community schools. One, the kids are in the community, they're comfortable there. There's a lot closer relationship between teachers and students. It's a lot easier to identify problems. There's much more personal to them, and you take those students out of there and put them in a consolidated county school over at the county seat, and they lose their comfort level. And of course, parent involvement in the small community schools was at a very high level. Community involvement was at a very high level. And of course the participation, the opportunities to participate and the opportunities for leadership are much higher in these community schools. The rates of participation on co-curricular and extracurricular activities were very high. There's a good example of that going on right now in Richwood, where they're trying to consolidate Richwood into one Nicholas County school. The students are all participating. I think the figure was something like 90% of students are in some co-curricular or extracurricular activity. They have the second largest band in the country. It's a single A school. It's a single A school, and they have 135 band members, and they're good. And it's a high-performing school, despite the fact that it's got over 60% of the students are on school lunches, an indication of low economic status. Despite that, it's a high-performing school. It's received 3 national awards in the last 8 years. It has a 97% graduation rate, and it scores above the average in 3 of the 5 factors for measuring schools in the state. So, and that's just an example of what we did when we closed all these schools. And it's also true that there's been studies replicated now in 11 different states around the country, including West Virginia, that verify what common sense tells us. And these, again, we're all over the country and in different kinds of states, that community schools facilitate higher education performance by low socioeconomic students. And common sense tells you why. And that's been 11 different times now, and it's come up with the same results every time. And despite that, we just marched on to consolidation. There was a case challenging that, arguing that the school building authority's formula basically rigged the process and forced kids into consolidation, and that was denying them the ability to get a thorough and efficient education, at least for low socioeconomic students. The circuit court, in fact, bought that argument and enjoined the SBA, but the Supreme Court reversed that, and I'm still cursing at Larry Starcher. So I'm sorry we don't have time for questions, but I appreciate your attention and attendance. Thank you. Good job. I enjoyed that. Me too.
It keeps getting warmer. I'm watching the thermometer. Lexi and I keep yelling at different people.
I enjoyed your presentation. I enjoyed yours as well. I didn't know that some of that background.
Yeah, Leslie, that doesn't actually control the temperature in here. We let it see, it's turned out.
Had I seen that, I would have been my. And then you had the mouse squeaking up in the.
It's not better.
This is not a good rate.
She would say to get on the bus early and everybody would
Hey, John, I saw you back
Presenting, I got a text from
I told Leslie,
Yeah.
they call facilities, I don't know. They call
It'll get cool by the time we leave.
Is he doing what I wasn't sure?
Hopefully they leave it on tomorrow.
Yeah,
Hope it was important.
It was.